Hello everyone and welcome to Lawminds. So in this video we are going to be discussing about the two most important parts of the Indian Constitution, that is none other than the fundamental rights and the directive principles of state policy. So in this video we'll be discussing in utmost detail about the relationship between these two parts on various aspects with the help of some of the landmark judgments of the Indian history. As we all know, the fundamental rights and the directive principles of state policy are two of the important salient features of our constitution. The Constitution of India is the supreme law of the country. It is the lengthiest constitution and the most detailed of all the written constitutions of the world. The Indian Constitution, when it was enacted or when it came into force in 1950, it consisted of 395 articles divided into 25 parts and 8 schedules. But now it consists of 448 articles categorized into 24 parts and 12 schedules. Till last year, there were 25 parts in our Indian constitution, but after the Rajesha ruling by the Supreme Court, the part 9b dealing with the cooperatives was outlawed, which led to the constitution now having 24 parts only. Before moving on to our topic, that is the relationship between the fundamental rights and directive principles of state policy, we have to first understand what are fundamental rights and what are DPSPs or directive principles of state policies. Let us start with the fundamental rights of our constitution. Enshrined in Part 3 of the Indian Constitution, fundamental rights are the basic human rights guaranteed by the Constitution of India. There are six fundamental rights, which includes the right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and the right to constitutional remedies. These rights are enshrined in Articles 12 to 35 of Part 3 of the Constitution of India. Originally, right to property, which was also a fundamental right under Article 21. However, these right or these fundamental right was made a legal right. It was deleted after the 44th Constitutional Amendment Act of 1978, and it was made a legal right under Article 300A of the Constitution. Now, the development of fundamental rights in India is heavily inspired by the United States Bill of Rights. These rights are included in the Constitution because they are considered essential for the development of the personality of every individual and to preserve human dignity. The fundamental rights, or the Part 3 of the Indian Constitution, is also called the Magna Carta of the Indian Constitution. The peculiarity of fundamental rights is that these rights are prohibitions against the state, that is, they are rights available against the state. The state cannot make any laws which are inconsistent with the fundamental rights of our constitution. Any such laws or actions by the state shall be declared void or unconstitutional by the courts. But it is also to be understood that the mere declaration of certain fundamental rights will be of no use if there is no machinery for their enforcement. That is the reason why the Constitution of India expressly provides for provisions which provides for the power to grant most effective remedies in case of the violation of fundamental rights in the nature of writs. There are five writs, that are habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Now, a person can enforce these writs before the Supreme Court or the High Court of India when their fundamental rights have been violated by the state or any other person. It has to be remembered that the fundamental rights are not absolute rights. They are subject to certain restrictions, especially when it comes to rights conferred under Article 19. This is to strike a balance between the individual liberty and the social interest. When it comes to the directive principles of state policies, these are a set of guidelines or principles enshrined in Part 4 from Articles 36 to 51 of the Constitution of India. Unlike fundamental rights, which are justiciable and can be enforced by the courts, directive principles are non-justiciable in nature. This means that they are not legally enforceable by the courts, but they serve as important guidelines for the government in formulating policies and laws. The provisions contained in this part cannot be enforced by any court, as I mentioned earlier, but these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles while enacting any law, while legislating any law. The concept of directive principles of state policies was borrowed from the Irish Constitution, that is, the Constitution of Ireland. While most of the fundamental rights are negative obligations on the state, DPSPs are positive obligations on the state, though not enforceable in a court of law. Hence, the idea of a welfare state envisaged in our constitution can only be achieved if the states endeavor to implement them in a high sense of moral duty. Now let us thrive into a topic which deals with the various aspects which relates and differentiates the fundamental rights and directive principles of state policies. The first one is regarding the source of these two parts. The fundamental rights, as I mentioned earlier, is derived from the Constitution of USA or the US Bill of Rights, while the directive principles of state policies are derived from the Constitution of Ireland. When it comes to the nature of rights which are enshrined in under these two parts, the fundamental rights deals with civil and political rights of an individual, while the directive principles deals with the social, economic, and cultural rights of an individual. And when it comes to enforceability, which is a very important aspect, fundamental rights are justiciable in nature, while DPSPs are non-justiciable in nature. It simply means that fundamental rights can be enforced before a court of law via writs, the five writs. But in case of directive principles, no person can approach the court of law stating that directive principles are violated. The directive principles are only directions to the state on the principles which they have to follow while making a law. This is not a mandatory obligation on the state. The state do not have to mandatory follow these directive principles. The next aspect is that these rights, the fundamental rights, are available against the state, and the directive principles should be made available to the citizens by the state. Since the fundamental rights are civil and political rights, these rights are available against the state. The state cannot violate or make any law or act in any way such that the fundamental rights of the people are violated. In such a case, the actions or laws can be made void or declared unconstitutional. But when it comes to directive principles, these rights should be made available to the citizens by the state. The state has to make sure that while legislating or while enacting various legislations, the state has to make sure that they provide certain rights, these social, economic, and cultural rights to the citizens. Now, the last aspect is that the fundamental rights aims at political democracy, while the directive principles aims at social and economic democracy of the country. As we go through all of these aspects which differentiates the directive principles of state policies and fundamental rights, the question still remains. That is, which one is more superior, the directive principles or the fundamental rights? Now, the conflict between the fundamental rights and directive principles can be understood with the help of a series of landmark judgments as shown here. Now, the first case is the state of Madras versus Champakan Dorai Rajan. In this case, it was held that in case of any conflict between fundamental rights and directive principles, fundamental rights would always prevail. But in state of Bihar versus Kameshwar Singh, in this case, the court relied on Article 39, a directive principle, in deciding that a certain Zamindari Abolition Act had been passed for a public purpose within the meaning of Article 31. So in this particular case, the court relied more on a directive principle than on a fundamental right. And in the landmark judgment of the In Re Kerala Educational Bill case, in this particular case, the Supreme Court observed that though the directive principles cannot override the fundamental rights, nevertheless, in determining the scope and ambit of fundamental rights, the court may not entirely ignore the directive principles but should adopt the principles of harmonious construction and should attempt to give effect to both as much as possible. So, in this particular case, the attempt was given to give effect to both of these parts, that is both fundamental rights and directive principles of state policy as much as possible, and it was also observed that a principle of harmonious construction should be given when a conflict occurs in any case between these two parts. In the Mohammad Hanif Qureshi versus State of Bihar case, a state law which prohibits slaughter of cows and calves and other cattle capable of work had been upheld because it was meant to give effect to Article 48 of the Constitution. Similarly, in Orient Weaving Mills versus Union of India, Article 44 has been referred to in upholding validity of the excise rules empowering the central government to grant exemption from payment of duty to small cooperative societies of weavers producing cotton fabrics on power looms. So in both these cases, predominance or superiority was given to the directive principles. Thus, although in the earlier decisions of the court paid less regards to the DPSPs on the ground that they are not justiciable in nature like the fundamental rights, yet in its later decisions, the court had taken the view that there is no conflict between the directive principles and fundamental rights and that they supplement each other in aiming at the same goal, bringing about a social revolution and the establishment of a welfare state which is envisaged in the preamble of our Constitution. The courts have the responsibility to interpret the provisions of the Constitution in such a way that it ensures the implementation and harmonious construction of the directive principles with the individual rights. In the landmark judgment of the Keshwananda Bharati versus State of Kerala, which is also known as the Fundamental Rights case, in this particular case, the court in its judgment said that fundamental rights and directive principles aim at the same goal of bringing about a social revolution and establishment of a welfare state, and they can be interpreted and applied together. They are supplementary and complementary to each other. It can well be said that directive principles prescribe the goal to be attained and the fundamental rights lays down the means by which the goal is to be achieved. Now let us look specifically into the relationship between the DPSPs and Article 19 of our Constitution. Now we all know that Article 19 gives for the fundamental freedoms. Now these freedoms are not absolute freedoms. The rights which are conferred in Article 19 are not absolute rights. They are subject to certain reasonable restrictions. Now, a restriction which promotes any objectives embodied in the directive principles is usually considered reasonable by the court of law. Let us look at two of the most important cases which deals with this matter. The first case is the State of Bombay versus F.N. Balsara. In this particular case, the Supreme Court gave way to Article 47 which directs the state to bring about prohibition of consumption of intoxicated drink except for medical purposes and to support its decision that the restriction imposed by the Bombay Prohibition Act was a reasonable restriction on the right to engage in any profession or carry on any trade. In the case of Bombay Cotton Mills versus State of Ajmer, in this particular case, the Supreme Court upheld the constitutional validity of the Minimum Wages Act 1948 because it was enacted to give effect to DPSP in Article 43 of the Constitution. It was held that the fixation of wages for laborers did not violate the freedom of trade under Article 19 Clause 5. I am concluding this topic with the sayings of Granville Austin. Granville Austin had described the fundamental rights and the directive principles as the conscience of our Constitution. There is no antithesis between fundamental rights and DPSPs. They are meant to supplement one another. While Part 3 contains negative injunctions to the state not to do various things, Part 4 contains positive command to the state to promote what may be called a social and welfare state. When it comes to the judicial interpretation of these two parts, in its earlier decisions, the Supreme Court gave more importance to the fundamental rights, which have an overriding effect on the DPSPs. Later, the courts applied the harmonious interpretation to maintain a balance between the two in case of any conflict. Even though DPSPs are expressly meant non-justifiable, presently the court declares the enforceability of directive principles like fundamental rights. This was all about the topic. Thank you. And if you like this video, please like, share and subscribe to the Lawminds channel. Thank you.